Hello, my name is Ankit Yadav. I am an advocate and I work primarily at the Supreme Court of India. Today, I would be talking about the Constitution Design Separation of Powers module under the Comparative Constitutional Law clause. While doing so, I would be talking about 4 jurisdictions, namely United Kingdom, United States, France, and India. Now I'll start with giving you a brief introduction about the doctrine of separation of powers and how it is relevant today. The shift from monarchy to democracy was premised on the concept that all power should not rest in one person. The doctrine of separation of power envisages a system of government wherein the 3 branches of government, that are executive, legislature, and the judiciary, work independently within their own sphere without intruding into the domain of another. To understand this doctrine, it is necessary to understand how this doctrine actually developed. Aristotle was the first person to differentiate the functions of government into 3 categories: A. Deliberative, B. Magisterial, and C. Judicial. Locke too gave a 3-fold classification of the power of the government, namely continuous executive power, discontinuous legislative power, and federative power. While continuous executive power refers to executive and judicial power, discontinuous legislative power implies the rule-making power, and federative power signifies the power regulating the foreign affairs. The concept of separation of power was understood in its present form was developed by Montesquieu. The term separation of power was coined by him in 1947 in his book The Spirit of Laws. According to him, no one person or body should exercise all 3 functions of the government, namely the legislative, the executive, and the judiciary, thereby meaning that limits should be laid on the functions and powers of every branch of the government so that each branch functions within its own sphere without transgressing into the domain of the other. This doctrine seeks to prevent concentration of power by providing checks and balances. This doctrine can be best explained in the following words of Montesquieu, and I quote, "When the legislative and executive powers are united in the same person or in the same body or magistrate, there can be no liberty. Again, there is no liberty if the judicial power is not separated from the legislative and executive power. Were it joined with the legislative power, the life and liberty of the subject would be exposed to arbitrary control, for the judge would then be the legislator. Were it joined with the executive power, the judge might behave with violence and oppression. There would be an end of everything were the same man or same body to exercise these 3 powers." Thus, the theory of separation of power can be explained in the following way: that the same person should not form part of more than one of the 3 organs of the government, that one organ of the government should not interfere with other organ of the government, and that one organ of the government should not exercise the functions assigned to another organ. Almost all democratic governments have adopted this doctrine in some form or the other. Let us now briefly analyze the status of the doctrine in United Kingdom, United States, and France before examining the doctrine in the context of India. In England, the legislative supremacy of the Parliament came after a long war between the Parliament and the King. Ultimately, legislative and tax power of the Parliament and the judicial power of the court were recognized. Thus, while the legislative and judicial power resided with the Parliament and the judiciary respectively, the executive power resided with the King. However, later on, parliamentary form of government was adopted in England. Thus, England does not conform strictly to the doctrine of separation of power, as there are visible overlaps between the legislature, executive, and the judiciary. In UK, the Crown and the government, including the Prime Minister and the Cabinet Ministers, form the executive. The executive formulates and implements the policy. This legislature, that is, the Parliament, comprises of the Crown, the House of Commons, and the House of Lords. The judges in the courts of law form the judiciary. The Prime Minister and the Cabinet are part of the executive as well as the legislature, as they are members of the House of Commons. Though there are certain overlaps, as you may evidently see, efforts are made to provide appropriate checks and balances, which are very necessary in today's form of government. Earlier in UK, the post of Lord Chancellor combined in its power of all three organs of the state and was thus an exception to the doctrine of separation of power as we know. He was the head of the judiciary of England and Wales, a member of the cabinet and Speaker of the House of Lords. However, this post was abolished by the Constitution Reforms Act 2005. This act removed the judicial functions of the Lord Chancellor. His judicial functions are now performed by the Lord Chief Justice. Also, the Lord Chancellor no longer acts as the Speaker of the House of Lords, as the House now elects its own Speaker. Thus, the Act created a more formal separation of powers as compared to what was existing earlier in the United Kingdom. This signifies that this doctrine does not hold importance in UK, even though while there is no this signifies that this doctrine does hold significant importance in the UK, even though while there is no strict compartmentalization of powers and functions of executive, legislature and the judiciary, efforts are made to prevent concentration of powers of all three wings in one person or in any one office. Thus, the doctrine does hold relevance in today's context. Now coming to the separation of powers in the United States. United States Constitution closely follows the concept of separation of powers. The legislative, executive and judicial powers reside in separate organs in the American Constitution. Section 1 of Article 1 declares, all legislative powers herein granted shall be vested in a Congress of the United States. Section 1 of Article 2 says, the executive power shall be vested in a President of the United States of America. Section 1 again of Article 3 reads that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Despite such a segregation of functions by the Constitution, United States does not adhere to the concept of separation of powers in its rigid sense. The complexity of the modern day government has shown that strict structural classifications are not possible. This can better be understood by the following examples. The first one being, if you know the President possesses the power to veto bills of the Congress. Such bills cannot become law unless they are subsequently passed again with a 2/3 majority of each house. Thus, the President also exercises legislative power in making of the treaties. Therefore, if you see these examples, the President possesses powers that are both executive and legislative in nature. Further, the President also appoints the judges of the Supreme Court, therefore having some say in the judicial powers as well. The Congress now interferes with the powers of the President by casting vote on the budget. The Budget and Accounting Act 1921 established the principle and practice of executive budget, under which the President is responsible for formulating and presenting to Congress a complete and detailed expenditure plan for the following fiscal year. Also, Congress approves the appointment of the judges and can also remove judges by impeachment process. Therefore, again, you can see that there is no strict compartmentalization, and Congress also, in a way, possesses some judicial and executive functions. And finally, when we talk about the judiciary through its power of judicial review interferes with the powers of Congress and President every now and then. Therefore, as we can see, all three organs of the government have some overlapping functions, thereby not complying with the separation of powers in the very strict sense. Therefore, in both United Kingdom and United States, the doctrine as propounded by Montesquieu is not strictly adhered to even though there is a difference in the constitutional setup of both the countries. While the former is a parliamentary democracy, the latter follows a presidential system. Given the differences in the government setup and existence of explicit constitutional provision, it may seem that this doctrine operates in its strict form in the United States. However, as we have already seen that this is not the case. This is because the modern day government is too complex to allow strict segregation of powers and functions. Every organ has to act as a check and has to balance the other two organs of the government. Thus, despite the difference in government setup of the two countries, that is, the United Kingdom and the United States, we find that there is considerable overlapping of functions in both the jurisdictions. Now, talking about France, Montesquieu's doctrine of separation of powers was incorporated in Article 16 of the French Declaration of Rights of the Man. It is stipulated that Article 16 It is stipulated under Article 16 that any society in which no provision is made for guaranteeing rights for the separation of powers has no constitution. Thus, according to this declaration, there could be no constitutional or democratic government without the separation of powers. This is the kind of importance granted by the French legal system to this doctrine. Under the influence of this doctrine, the ordinary courts were earlier prevented from reviewing the validity of the legislative enactments and administrative actions. Separate administrative courts were formed for adjudicating disputes between the citizens and the administration. However, there is no strict adherence to this doctrine in France also. Now finally, dealing with the separation of powers in India. There is no explicit mention of this doctrine in any part of the Constitution. The only article which hints at this doctrine is Article 50, which says that the state should take steps to separate the judiciary from the executive in the public services of the states. However, this directive principle does not embody any formalistic or dogmatic division of powers. There is no formal separation of powers in the Indian Constitution. Rather, a parallelism of power in hierarchies between these three organs in particular fields exists. How far this doctrine is embedded in India's constitutional setup can be better understood by briefly analyzing the Constituent Assembly debates regarding the adoption of the separation of powers. In the Constituent Assembly debates, suggestion was made by Professor K.T. Shah, a member of the Constituent Assembly, to insert an amendment, a new Article 40A concerned with the doctrine of separation of powers. This amendment was supported by Qazi Sayyid Karimuddin. This suggested article read as follows: there shall be complete separation of powers as between the principal organs of the state, which are the legislative, the executive, and the judicial organ. Now, according to K.T. Shah, if you maintain the complete independence of all the three, you will secure a measure of independence between the judiciary, for example, and the executive, or between the judiciary and the legislature. This, as has been stated by K.T. Shah, in his view, is of the highest importance in maintaining the liberty of the subject, the civil liberties, and the rule of law. If there was contract between the judiciary and the legislature, for instance, if it was possible to interchange between the highest judicial officers and the membership of the legislature, then, as has been said by Professor K.T. Shah, the interpretation of law will be guided much more by party influence than by the intrinsic merits of each case. The legislature in a democratic assembly is bound to be influenced by party reasons rather than by reasons of principle. However, Shri K. Hanumanthia, another member of the Constituent Assembly, dissented from the proposal of Professor K.T. Shah, as he considered this article to sponsor presidential form of government, whereas the drafting committee had approved parliamentary system of government to be suitable for this country. He remarked that complete separation of the executive, judiciary and the legislature would inevitably lead to conflicts between these three departments of the government. Therefore, consequently, the motion of a new Article 48 dealing with the separation of powers was dismissed by the Constituent Assembly. This discussion signifies that the framers of the Constitution never actually wanted to adopt the doctrine of separation of powers in its rigid sense, as we saw is already provided under the US Constitution. The framers of the Constitution had already thought about what problems could arise in the future if doctrine of separation of power would be followed in its strict sense. They foresaw that the functioning of government was a complex process, and such a rigorous adoption would impediment the smooth functioning of the government. Thus, there are significant overlaps between the powers and functions of the three wings of the government of India. However, these overlaps serve as checks on the unwarranted use of power by any one branch of the government. The overlap between the three branches of the government can be illustrated by the following examples. For instance, the executive, that is, the Prime Minister and the Council of Ministers, is also a part of the legislature. The President's or Governor's assent is required to transform a legislative bill into an act. The President or Governor has the power to promulgate ordinances when both the houses are not in session. The ordinances also have the status of law in India. The Parliament also has the power to punish for contempt those who commit breach of privilege or defy its orders. Thus, the Parliament, which is the legislature, has been vested with judicial power in this regard. Judges also can be removed by the President on an address by both the houses of the Parliament presented in the same session. The address, though, must be supported by a majority of the total membership in each house, and also by a majority of not less than 2/3 of the members of each house present and voting at that time. The judiciary, through its powers of judicial review, can invalidate any act passed by the legislature if it violates the Constitution. Also, the judiciary can invalidate any executive action if it is found violative of the Constitution or any other laws, especially their parent statute, passed by the legislature. An analysis of the provisions of Constitution indicates that every organ is vested with all three functions: legislative, executive, and judicial, and is dependent on other organs in some respect, which check and balances it. Now let's talk about the judicial opinion on separation of powers. There have been numerous judgments of the Supreme Court of India which actually talk about and explain this doctrine, and also explain how important this is for the present functioning of the government, for a proper functioning of the government. The Supreme Court, for example, in its very important opinion given in Ram Javaya versus State of Punjab, has opined that the Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts or branches of the government have been sufficiently differentiated, and consequently, it can very well be said that our Constitution does not contemplate assumption by one organ or part of the state of functions that essentially belong to the other organs of government. Similarly, in another landmark judgment, which is considered to be one of the most important decisions given by the Supreme Court of India, Indira Gandhi versus Raj Narayan, this doctrine was upheld as a basic structure of the Constitution. In this case, the Prime Minister Indira Gandhi's election to Lok Sabha had been held invalid on the grounds that she violated Section 8A of the Representation of Peoples Act 1951. The appeal against this decision was admitted by the Supreme Court and the High Court's decision was stayed. While the appeal was pending, the Constitution 39th Amendment Act 1975 was passed, which stipulated that no election to either house of the Parliament of a person who held the office of the Prime Minister at the time of such election shall be called into question, except before such an authority or body in such a manner as might be provided for by or under any law made by the Parliament. This was seen as a clear transgression of the powers given to the executive or the legislature, as it was clearly encroaching upon the powers of the judiciary. It was also provided that notwithstanding any order made by any court before the commencement of the 39th Constitution Amendment declaring such election to be void, such an election shall continue to be valid in all respects, and any such order or any such finding on which such order was based shall be deemed to always to have been void and of no effect. The Apex Court held that the above provisions violated the basic structure of the Constitution. It opined that separation of powers is a basic structure of the Constitution, and therefore every dispute involving the adjudication of legal rights must be left to the decision of the judiciary. Thus the Supreme Court, in its opinion, accorded a sacrosanct nature to the doctrine of separation of powers by holding it to be a basic feature of the Constitution. Similarly, in another landmark decision, that is, the In Re Delhi Law Act, the case the Honourable Chief in the Delhi Law Act case, the Honourable Chief Justice of India, Justice Kania, observed that although in the Constitution of India there is no express separation of powers, it is clear that a legislature is created by the Constitution and detailed provisions are made for making the legislature pass laws. It is then too much to say that under the Constitution, the duty to make laws, the duty to exercise its own wisdom, judgment, and patriotism in making any law, is primarily cast on the legislature. Does it not imply that unless it can be gathered from other provisions of the Constitution, other bodies, executive or judicial, are not intended to discharge legislative functions? The doctrine of separation of powers has strong footing in the constitutional jurisprudence in India. The Supreme Court, in another case, State of West Bengal and others versus Committee for Protection of Democratic Rights, has remarked that it is right that in the constitutional system adopted in India, besides supremacy of the Constitution, the separation of powers between the legislature, the executive, and the judiciary constitutes the basic feature of the Constitution. However, the Indian concept of separation of powers comes with requisite checks and balances. India has not adopted the doctrine in its rigidity, but has indeed adopted the essence of the doctrine. The concept of checks and balances ensures transparency in the government. With regard to this concept, the Supreme Court has also opined that where an act made by a state legislature is invalidated by the courts on the ground that the state legislature was not competent to enact it, the state legislature cannot enact a law declaring that the judgment of the court shall not operate. It cannot overrule or annul the decision of the court, but this does not mean that the other legislature which is competent to enact that law cannot enact that law. Similarly, it is open to a legislature to alter the basis of the judgment while adhering to the constitutional limitations. In such a case, the decision of the court becomes ineffective in the sense that the basis upon which it is rendered is changed. The new law or the amended law so made can be challenged on other grounds, but not on the ground that it seeks to effectuate or circumvent the decision of the court. This is what is meant by checks and balances. inherent in a system of government incorporating the concept of separation of powers. Now, as we've seen, all these jurisdictions follow the doctrine of separation of powers and hold it to a pedestal, but they do not do so in rigidity. All of them follow it with certain modifications necessary for the modern form of government. Therefore, in order to conclude, I would like to say that though this doctrine cannot be applied in the strict sense to any modern government, it still serves as a guiding principle for the three wings of the government. The powers and functions of the executive, legislature, and the judiciary cannot be restricted by watertight compartmentalization. However, this doctrine precludes any unwarranted incursions by one organ of the government into the other organ of government. While strict application of this doctrine might lead to inefficient governance, a modified application of the same with appropriate checks and balances ensures that no organ is given unbridled power and each functions cooperatively with one another. In today's context, this doctrine can be interpreted as the principle of community of powers exercised in the spirit of cooperation by various organs of the state in the best interest of the people. Thank you. I hope that you found this discussion interesting and it would be useful for you.